Welcome to the Celebrity Estates Wills of the Rich and Famous podcast. In this podcast, we break down high-profile celebrity estate planning cases for advisors and their clients. Most celebrity estate catastrophes are based on the same issues that everyday people face, just with the volume turned up. Our goal is to identify and extract the individual estate planning issues that lie at the heart of each story. We then discuss what advisors should expect and how to avoid common pitfalls. Hosted by wealthmanagement.com senior editor David Lenok.
Every estate tells a story. Some define a legacy, while others highlight lessons learned the hard way. To avoid costly planning pitfall, trust companies, banks, and wealth management firms rely on the full suite of modern solutions from SS&C Black Diamond Trust Services. Whether optimizing for tax efficiency, managing complex assets, or securing intergenerational wealth, Black Diamond helps you bring clarity and control to the most complicated estates. Learn more at www.sscblackdiamond.com. SS&C Black Diamond, powering the future of trust and estate management. Hello, everyone, and welcome to the latest episode of wealthmanagement.com's Celebrity Estates, Wills of the Rich and Famous. For anyone new to the podcast, in each installment, myself and a guest take on a different celebrity estate and attempt to extract some key lessons that planners can apply to more traditional clients. The idea being that celebrity estate planning stories, although often ridiculous in their details, generally have at their cores very basic issues that can just as easily apply to non-famous or fabulously wealthy clients. To learn more about estate planning and how you can better serve your clients, visit wealthmanagement.com/trusts-estates. Our monthly journal features tax law updates, wealth planning, retirement planning, and much more, written by thought leaders in the industry. That's wealthmanagement.com/trusts-estates. Now, our guest this time is Lawrence D. Mandelker. Larry is a partner at Venable LLP and helps high net worth individuals with estate planning by counseling on multi-generational transfers of assets and business succession planning. Through the use of wills, trusts, and other estate planning instruments, Larry works with his clients to creatively design estate plans that address their unique needs and plan for future contingencies, while also focusing on asset preservation, premarital planning, and estate, gift, and income minimization goals. His clients include individuals in many industries, including corporate executives and founders, owners of closely held businesses, real estate owners and developers, financial principals, technopreneurs, entertainers, athletes, and publishers. Thanks so much for joining us, Larry.
Thanks for having me, David.
Now, the subject of today's episode is Terry Bollea, better known as Hulk Hogan. Hogan was a professional wrestler for anyone living under a rock and media personality widely regarded as one of the greatest and most globally recognized wrestling stars of all time. He won multiple championships worldwide, most notably a six-time WWF, then WWF, now WWE champion. And he was a key to that company's rise to dominate the wrestling business in the 1980s. Outside of wrestling, Hogan appeared in numerous films, most famously Rocky III, but also the lesser-known No Holds Barred and Suburban Commando, as well as television shows like Thunder in Paradise and Hogan Knows Best. However, after a lifetime of playing the all-American hero and encouraging children worldwide to say their prayers and eat their vitamins, Hogan courted quite a bit of controversy later in life. In 1994, he admitted to using anabolic steroids for 20 years, and he helped stop a wrestling unionization effort. In 2012, the media company Gawker published portions of a sex tape, which also featured Hogan using racial slurs. Hogan sued Gawker, which was found liable and subsequently went bankrupt. Despite this legal victory, though, Hogan's reputation was pretty much permanently tarnished, a fact likely not helped by his aggressive turn into hard-right politics. One of his final public appearances featured the real American, quote-unquote, mockingly posing in front of imprisoned immigrants at the Everglades Detention Center, nicknamed Alligator Alcatraz. His unfortunate death at age 71, after battling chronic lymphocytic leukemia and AFib in July, was greeted with largely negative sentiment, even by many who had once considered him a hero. He left behind an estate worth an estimated $25 million. Now, Hogan was married 3 times and twice divorced. He and first wife Linda married in 1983 and divorced in 2007. They had Hogan's only two children, Brooke and Nick. He later married Jennifer McDowell in 2009, a union which ended in 2021. And finally, he married Sky Daly in 2023. At the time of his passing, Hogan also had two grandchildren whom he had reportedly never met. From his public rise to fame and wealth to his fall from grace, as well as his multiple late-in-life divorces, Hogan's life reads like what those of us who attended law school would call an issue spotter. So let's start with the family. Larry, Hulk Hogan left behind what the industry would call a blended family. Do you mind elaborating on what that term means and some of the estate planning challenges it can present?
Sure, that's a great starting point. When we talk about blended families, we usually talk about families that don't look like a traditional family tree, where there may be multiple marriages, maybe some adoptions, some stepchildren, et cetera, or sometimes we call them interesting families. When we work, in the trust and estates world and the wealth planning world, we typically deal with intricate and fragile family relationships and real personal issues with our clients as they try to figure out what works best for them on an estate plan. And, blended families give rise to a lot of these, difficult issues, balancing interests. And there's, I'm sure you can imagine, there's this inherent strained relationship between, on the Hogan example, the children from the first marriage and maybe the third wife, there's a competing interest there. And sometimes the person in the middle, the client, can feel like doing one thing is going to favor one person and upset someone else. And, there's a lot of, you're running the gauntlet when you're doing these types of plans. You've got to be careful. There's a lot of things to be
done. Yeah, I always like to think of a blended family as sort of like a spider web. And they're sort of all eventually interconnected by the one person. And so the unfortunate problem is that when that person dies, you effectively just pluck the middle of the spider web right out, and the whole thing kind of can tend to collapse because the one thing joining all these people has been, removed. So, what are some ways that, when you're dealing with a blended family, in Hogan's case, it's pretty traditional with, with just step parents and stepchildren, but, given gay marriage and how much adoption there is, or even sort of racial or religious differences can create, major issues in a blended family. So in this case, what are some of the ways that, when you identify that I'm dealing with a blended family here, there could be problems, is how do you start to identify them and maybe head them off?
Good question. So when we speak to our clients, my primary goal when I'm speaking to a client is to make sure that their wishes are carried through. Okay. And and while there may be people expecting one thing or another, it's really up to them to decide who they're going to favor in their estate plan. And, like I sometimes remind them, you're not going to be around to hear the complaints. So do what you want to do. I think that just in speaking to a client, the initial meeting and the subsequent meetings with clients it's important to develop a rapport with them. Again, we're dealing with real intricate family issues and they have to trust us. And you have to listen actively. And every once in a while, you'll hear something that, sort of it sounds a little strange and then that's where you start pulling that thread and you start asking more about it.
Yeah, absolutely. And, I think, in any estate, but particularly with, blended families, sometimes they don't know that there's an issue yet. They might not even be aware. And so, things crop up, in the sort of stew of emotions that results from, a death from a trauma, a shared trauma. So, just having those conversations that you were talking about can, even help you identify issues that maybe the client isn't even aware of could be issues yet.
Right. Everyone may be getting along well when they're in the middle of it. But like you said, when they're plucked out of the spider web, and everyone's now, divvying up or seeing, what did they get versus what did I get? You realize that, maybe there were some underlying tensions all along. What we also notice is they may be arguing about property, who got the house or who got, grandma's engagement ring. But it's usually not really about that. There's usually an underlying thing. Who did they love more? Who did they value more? Who did more for them during their life? So there's a lot of these subjective feelings that, play out afterwards.
Yeah, there's a weird tendency to sort of look at the will or the estate plan as sort of like a life scorecard, right? Where like you can't quantify love in a number, but the numbers in the estate plan are dollar signs usually. So it's very easy to fall into that trap of equating like, oh, well, so and so gave more to the one they loved the most. Where in reality, that the person's reason for giving a certain amount to one heir and less or more to another are up to there can be millions of them. There could be because one needs it badly and the other doesn't. There are a number of reasons beyond just I love this one more, where there could be sort of inequality, so to speak, in a plan.
Absolutely. And I think it's important to make sure that the client, whatever the client wants to do, that's correct. This is the client. The client has amassed assets and worked their whole life, and this is their property. They get to do with it what they want, but just help them, make sure that they're not doing things for the wrong reason, that their plan reflects their wishes.
So that's really interesting that you put it that way, Larry, because I'm curious, actually. It's sort of obviously like you are representing the client, the decedent, the person who's making the plan. And you don't necessarily have responsibility to the next generation of the family. But, it is easy to see how, elements of that plan could affect them and lead to sort of strife in the future. Do you as a planner sort of feel any responsibility to nudge at all at the decedent if you see them going in a direction that's, maybe it's what they want, but maybe you can tell that like this is going to cause a problem?
Yeah, that's a really interesting question. And I think that, my primary goal is to make sure that my client's wishes are carried through. Mm-hmm. But I want to make sure that those are really my client's wishes. And if they do something that seems a little strange, I'm going to disinherit my son. I just had a fight with him, right? I do think it's my job to say, well, do you really want to do that? Or do you need a little bit of a cooling off period? Or is this really the final straw? And again, I'm going to take my directions from my client, but I think that sometimes, it's in the client's best interest to have an objective observer sort of say, let's just take a beat for a second and think about this. Mm-hmm. Not to change their mind at all, but just to let them understand what they're doing.
Mm-hmm. I think also it's good to bring up, that estate plans can change. Just because they've decided in the moment to disinherit someone or to make what maybe is a bit of a rash decision. It doesn't mean that has to be permanent. I mean, it can be if God forbid something happens in the interim. But if they cool down subsequently and decide that that was maybe a little too much, then it's totally possible for them to come back in and change the plan. Like there's a tendency to view estate plans as sort of like carved in stone, when really the opposite is what should be true.
Right, exactly. They're carved in stone, but that stone can be replaced. I think that's sort of important. I think it's also important for clients. Sometimes they perseverate over certain things constantly, and they almost get stuck. And I've said to my clients a number of times, it's better to get a B+ in the course than an incomplete. And get something on paper. Let's do the best job that reflects your wishes to the greatest extent we can do today. Let's build in flexibility, as you said, to take into account any changes in beneficiaries' needs in the future, any circumstances, your feelings about the beneficiary, build in enough flexibility so that we can change it, but let's get something done because, let's cross it off your to-do list. God forbid something happens at an unexpected point. We want to make sure that the people that you want to care for or the causes that you want to care for are cared for.
Yeah, that's a really wonderful point there, Larry. I think just from the things you listed and the nature of an estate plan having to sort of predict far into the future, often depending on when the person is writing, hopefully far into the future, that it's impossible to create a perfect plan. Like some fights are unavoidable. Some what happens in the future, you have no control over. You can't possibly predict. I mean, who would, 30 years ago, would we predict, iPhones or something as simple as that? It completely changes life. We always thought there would be flying cars, but that's not the way technology went. It completely changes the way we live. So it's impossible for an estate plan to sort of capture everything and to cover every potential conflict. I always like, you said, I like to use the statement, the saying, don't let perfect be the enemy of good. And then sort of just to echo what you were saying, this idea that, get something down and then keep it flexible and we can change it as things develop.
Exactly. I tell my clients sometimes, this will or this estate plan has to work if you, walk out of my office and you get hit by the bus. And also if you put it in a drawer, you put the document in a drawer and you don't look at it for 30 years. So we want to make sure that it's going to change with the times, that it's going to give enough flexibility.
Yeah, absolutely. And I think to remember is that just because there's conflict or just because, some things are unavoidable, like that doesn't mean the plan necessarily has failed. If the conflict is resolved, then the plan is, successful. Some fights are just going to happen and they have nothing to do with money, or they're fighting about something else completely that just has nothing to do with the estate plan and that no words on paper could possibly have solved.
Absolutely. I do think, that it is our obligation to, when you have that type of situation, to try to buttress and strengthen the plan and take into account those risks. There's a lot of tools that we have. You can use an interim or a no contest provision if you're really worried about, someone objecting to a will and litigation, to try to settle that. Often if you see the stormy skies ahead, you can take actions today that will resolve that. The last thing that, we really want is, protracted, extensive litigation, because that's not in anyone's interest. It takes a long time. It costs a lot of money for everybody fighting over it. So if we can do something at the outset that will alleviate those concerns, or at least move some issues to the side and narrow what the fight is going to be, then we've accomplished a lot, even though it may never, come to fruition.
Mm-hmm. So, one of the interesting things that often happens with, blended families specifically is there's a tendency to want to pick and choose sort of who gets what a little bit, in terms of, I really love my son's ex-wife who has who's the mother of my grandchildren, but his new wife, I don't know, I don't want her to really get any of this, or any different, there's a million different permutations of, members of this blended family who are like, oh, I wanted to skip them, but then their children are my grandchildren, so I care about that. What are some of the techniques that you sort of use as go-tos when you have a client who's really sort of trying to just pick their spots in that manner, and really sort of there's drop different, skip generations and then sort of drop things in?
We've got a lot of techniques, and thankfully there are a number of vehicles that we can use to get the client to where they want to go. Whether that's, using an estate plan that doesn't go into action until they die, or doing some pre-death planning, making gifts, for instance, setting up trusts during life, so that will allow us to, usually accomplish what they want to. And again, we can, their planning, the major theme here is that the client's wishes should take precedent. And we can draft a plan, we can formulate a plan that will effectuate their wishes. We can build in flexibility. There are things called powers of appointment, which allow, a trust to be almost rewritten in the future. There's, things that we can do, down the road with decantings, and, maybe you change a trustee, just to make sure that what they want occurs.
Absolutely. One of the aspects of, that you just brought up of estate planning, this idea that, doing things during life is sort of often an overlooked element of, with estate planning, we have a tendency to sort of think about at death, this is, death planning. But generally, the more you can do during life for the plan, the better, for a number of reasons. First, just because it's easier to see the repercussions, but also because, your client is there to explain themselves a lot of the times. Whereas, with when things are happening, gifts are made during life, you can explain, hey, this is why, anyone's bent out of shape about it, you say, this is why I did this. Whereas, a bequest, through, hard, black letters on paper can often come off as much colder and, more open to, wild interpretation in terms of, you're trying to sort of read the tea leaves of the idealized version of a person who's not there anymore.
Yeah, absolutely. And I think that it's for the clients whose families are in a position to be able to have those conversations, as as touchy or as difficult or as uncomfortable as they may be. It's a good thing to have that conversation early, so it's not a surprise down the road. If you think about a parent with multiple children, with more than one child, very often they say, well, how do I divide? And I think you mentioned earlier, one child's very wildly successful and maybe the other's wildly successful, but not in an economically beneficial sort of way. Maybe one is, a tech has just founded a new internet company, but your other child is, the greatest social worker in the state. And, many times the parents will say, well, what do I do? And, I try to remind them, fair isn't always equal and equal isn't always fair. And different children have different needs. And maybe you've helped one along the way, put a down payment on a house, or you've given more to them when they were unemployed, and now you want to equalize the other way. So, it's really up to the parents to figure out what do they want to do. And they don't have to answer to anybody, but I think it's important for them to take into account the fact that someone's perception of a plan that gets sprung on them after their parents are gone may be different than what the parents intended.
Mm-hmm. So, we've been talking a lot about, the client, obviously, as we should. I think, but in the specific case of Hulk Hogan, there's been some rumbling that his daughter Brooke, may want to renounce her inheritance. So I guess that sort of begs an interesting question of, this is what the client wants to do, but what if the kids just say no? And what does that look like, and what can kind of happen?
Sure. So, Brooke, as his daughter, as the beneficiary, can't prevent Hulk Hogan from giving something to her. Okay. But she can decide, I'm not going to take it. And I think that it sounds like that's sort of where we are right now. And, you use the term renunciation and disclaimer, and that's a mechanism whereby a beneficiary refuses to accept the property. And the mechanics of that is that the beneficiary is treated as having predeceased. And I guess the first question that someone would say is, well, why would someone do that? Okay. And, I think we have to understand it. There could be a subjective reason, like they had a poor relationship, like it seems was the case here. But there could be some objective reasons, more strategic reasons to do it. For instance, there could be tax reasons. It's more tax efficient to let the property go someplace else. Or, less often thought about is maybe the beneficiary has creditor issues. And if the property goes to them, the creditor is going to grab it. So that may not be what, the decedent, the person who died, mom and dad, would have wanted. So, beneficiaries in those situations, whether it's the subjective or the objective reasons, have the right to disclaim the property. Now, usually for someone that's talking about doing that, we counsel them to, the first thing is make sure you know where the property is going to go if you don't take it. Okay. So don't say, I don't want it, but I want it to go to my kids. Well, that's not your choice. Right? You're treated, if the will says, Hulk Hogan's will says, I give $100,000 to Brooke, or if she's not alive, it goes to, my wife, then Brooke doesn't get to say, I want it to go to my kids, right? If Brooke says, I'm renouncing it, I'm disclaiming it, then she's treated as having deceased, and under the will, it goes to Hulk's wife. So the clients need to know what the effect is going to be. Once you renounce, once you disclaim, it's irreversible.
It's an all or nothing affair.
Exactly. It's irreversible. And, there's a number of requirements. You really should be talking to an attorney if you're in that type of situation, because, you've got a limited amount of time to do it. You've got 9 months to do it, which can sometimes be a harsh result because the 9 months begins when the gift was made. when the property was irrevocably given. So that could be during life if it was a gift, and even if you didn't know about it. So there are certain trusts where you may not know there's a trust that you're named as, but your 9-month clock has already started ticking. There's other requirements. It has to be in writing. You can't receive any benefits. So if you cash the check and then decide to give it, too late. You can't give it away. And also you have no direction, no control over where it's going to go. So for someone that makes the decision to renounce, we want to make sure that they're doing it in the proper way.
Absolutely. We're just about all out of time here. I'd like to thank Larry Mandelker for joining us and for being a wonderful guest and talking about some complex family things, which often don't necessarily lend themselves to numbers. They're a little bit of a softer topic, but they're just as important as the sort of as the hard numbers in an estate. Thanks so much for joining us, Larry.
Thanks for having me.
And for all our listeners, I'll see you, or I guess you'll hear me, on the next episode of Celebrity Estates, Wills of the Rich and Famous. Every estate tells a story. Some define a legacy, while others highlight lessons learned the hard way. To avoid costly planning pitfall, trust companies, banks, and wealth management firms rely on the full suite of modern solutions from SS&C Black Diamond Trust Services. Whether optimizing for tax efficiency, managing complex assets, or securing intergenerational wealth, Black Diamond helps you bring clarity and control to the most complicated estates. Learn more at www.sscblackdiamond.com. SS&C Black Diamond, powering the future of trust and estate management.
Thank you for listening to the Celebrity Estates Wills of the Rich and Famous podcast. Click the subscribe button below to become notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of InformaWealthManagement.com. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.